Hello and welcome everyone. My name is Norani Lidjon and I am Senior Lecturer in Law and Director of the Information Law and Policy Centre, one of the academic centres based at the University of London's Institute of Advanced Legal Studies and Joint Editor-in-Chief of the International Data Privacy Law Journal published by Oxford University Press. And it is my very great pleasure to welcome you here today to CPDP, and I'm delighted to be moderating this very important and timely panel on emerging patterns in EU digital regulation. So as many of you will be well aware, the EU has pursued an unquestionably ambitious and complex digital policy-making agenda for nearly 2 decades, from its reforms of EU data protection law to the implementation of a multitude of legal initiatives under the digital strategy launched in 2020. Embracing digital regulation has become a norm for the EU. As a result, the EU has firmly placed itself at the forefront of AI regulation and digital policy making worldwide. This intense period of policy making has also raised questions regarding the impact and the realization to date of what has been the effects of the overall EU digital rulebook. Recently, we've also seen a clear shift towards enabling a more competitive EU, following recommendations in the Draghi report from last year, and also to foster greater compliance and simplification of the wider digital framework, including, but not limited to, the AI Act, as stated in the AI Continent Action Plan published just last month. All of these major legislative and policy developments raise the following key questions. 1, what are the emerging trends in the implementation of the EU digital framework? 2, which institutions are emerging as the key actors in the implementation of the EU digital acquis, and how do they engage with each other? 3, how can the success of the EU digital framework be measured? What are the appropriate metrics? And finally, what challenges are emerging as a result of current implementation practices? These are very big questions, but that's okay because we have a stellar lineup of speakers here this afternoon, bringing expertise from regulation and insights from their experience in policymaking, oversight and enforcement, legal practice, civil society, and academia. Our first speaker today, and I have to apologize to her in advance for my pronunciation of her surname, so my sincere apologies, Karolina. It will be Karolina. One more time.
Mojzesowicz.
I would have gotten that so wrong, so thank you so much, Karolina. She is Deputy Head of Unit for Data Protection at the European Commission with DG Justice. Karolina is responsible for leading policy on implementation of the GDPR in the EU and for the streamlining and ensuring coherence of data protection provisions in all legislation within the EU digital strategy. Our second speaker here with us today is Anu Tallis. Anu has served as the Finnish Information Commissioner since autumn 2020. She is head of the Office of the Information Commissioner, TSV, and the chair of the European Data Protection Board. In her previous role at the Finnish Ministry of Justice, she led the implementation of the GDPR in Finland. Our third speaker will be Charles Albert, or Charlie Helleput. Charlie is a partner at the Belgian office of the international law firm King & Spalding. His practice and areas of expertise focus on EU privacy, cybersecurity, and digital law. Charlie also lectures on these topics at UC Louvain and at the Catholic University of Lille. Our fourth panelist is Matthias Spielkamp. Matthias is founder and executive director of Algorithm Watch, a nonprofit based in Berlin and Zurich that fights for a world where algorithms and AI are used to strengthen justice, human rights, democracy, and sustainability. He is also a member of the Advisory Council to the German Digital Services Coordinator elected by the German Bundestag. And last, but not at all least, our final speaker will be Professor Dr. Max von Gravenstein. He co-directs the governance of Data-Driven Innovation Research Program at the Alexander von Humboldt Institute for Institute and Society. In 2018, he was appointed Professor of Digital Self-Determination at the Einstein Center Digital Future, based at the Berlin University of the Arts. Max is an expert in the areas of data protection and internet technology law more broadly. In terms of format, our expert panel will present their interventions. The speakers will then all have an opportunity to discuss and share any reflections or responses on points and provocations raised. And then we welcome any questions from the audience with the time remaining. So I will now invite Carolina to begin our discussion on emerging trends, implementation and enforcement in the EU digital acquis. Carolina, the floor is yours.
Thank you very much, Nora. Thank you for having me. Still good morning, probably, to everybody. The trends. I think I would start with what we want to achieve. And this is the trend which we are supporting and working, on which we are working. First and foremost, consistency. Consistent, coherent enforcement and interpretation of all the pieces of legislation. Having said that, we do realize that we have problems with the consistency already still within the enforcement of the GDPR. These were the findings of in our report on the application of the GDPR from July last year. And the Commission, we engage as much as we can in order to counter that. But let me focus, Nora, a little bit more about this consistency more across variety of, or across, not variety, across different pieces of legislation from our digital package. So here I would think in particular pieces of legislation which build on concepts, terms, notions from the GDPR. So DMA, first and foremost, where we have a great example of how much this consistency is required while evaluating the pay and OK and the actions national data protection authorities, the EDPB concerning the GDPR and the Commission took under the DMA concerning the assessment on this precise conduct and how much it is interconnected. And of course, DSA, but also what will be in the future, DA, Data Act, and of course, artificial intelligence. And what do we have there and what is the trend? To establish and to foster more the cooperation once between the enforcers through already established structures like high-level group or the innovation board, so really more a structure where the enforcers come together and exchange on at least interpretation of certain notions, which will be then feeding into the application of the norms for which they are competent in particular cases. Second is the solution we provided in the NIS directive, where we have a very concrete solution for, on the one hand, notification of cybersecurity incidents and data breaches. Then the second group would be more informal cooperation between the enforcers while using the tool they have. And here I would refer to the guidelines on the interpretation of GDPR notions, be it in the DMA, be it in the DSA, and or the AI on which the European Data Protection Board and then the Commission with the different hats, enforcer of the DMA, to some extent enforcer of the DSA and AI office cooperate. And finally, also thirdly, and a little bit softer tools. For example, all this cooperation European Data Protection Board and consumer organizations developed and the subgroup devoted to that. And thirdly, under this hat, consistency and really this push for consistency is what the member states do on the national level. And here I think in particular about this digital cluster in Germany where the different ministries cooperate together so that there is a consistent enforcement of the digital regulation. Or, for example, this cross competences which were provided for in Ireland so as to force out the regulators to cooperate since they have so many cross competences established while Ireland was deciding which regulator is responsible for which area of law. Now, another trend, and I think we had a very interesting discussion this morning, and of course all the events from yesterday evening, is how to really provide for more and quicker decisions while, in particular here, the GDPR is enforced, because the DMA provides for a very clear already procedural setting, and by when this decision should be taken. This is a fairly strict setting. The DSA is a little bit different. But so this is what I would think are the trends. Maybe let me, Nora, mention one more. It's this trend which consistent while pursuing different objectives, because under these different regulators pursue sometimes very different objectives. DMA is about fair contestable markets. DSA, it's about safe internet, so the regulation of the intermediaries. But there a balanced approach which really owns to the risk-based approach which is provided for in the GDPR, and which in the recital 4 so nicely expressed this need to, while enforcing the regulation, the GDPR, to take into account also other fundamental rights. So probably when GDPR notions will be also used in other pieces of legislation, this push for a balanced approach will be really will have to be translated, because different objectives are pursued, right? You have already. So, thank you. This would be I thought it was Lyrics. Go ahead.
Thanks so much, Carolina. Thanks so much for giving us a really clear overview of the landscape of the different elements that make up the digital acquis, and then also the importance of there being consistency across key definitions in these diverging pieces of legislation. I think it'll be very important to know going forward the relationship between key foundational frameworks like the GDPR, the Law Enforcement Directive, and how that will speak to more recent pieces of legislation such as the AI Act. Anu, thank you.
Thank you. So the implementation of the digital laws, they do require involvement of multiple key stakeholders. To start with, the data protection authorities at the European level, the data protection authorities, we do play a crucial role in this context, in particular when it comes to enforcement. We have a long history of cooperation, and this is stemming from the duty to cooperate under the GDPR. And we have developed already, for example, common tools like IMI to exchange information and implement the GDPR workflows for cross-border cooperation. And we are committed to set smooth functioning of the one-stop shop and other cooperation and consistency provisions set out under the GDPR. Also, reinforcing common culture of enforcement and effective cooperation. This is one of the pillars of the EDBB strategy for 2024 till 2027. So the EDBB has been working to ensure cooperation and effective enforcement of the members. So on more practical terms, the data protection authorities, we discuss on concrete cases. The data protection authorities, they developed EDBB guidelines on enforcement topics like administrative fines or Article 65. Also, the data protection authorities, they exchange on their procedures and tools. I could also mention the support pool of experts and coordinated enforcement framework and the EDBB secondment program. In the last years, European data protection authorities have also been working together and cooperating to ensure responsible innovation. Just to give an example of that, for example, in the plenary meeting this year, February, the EDBB decided to extend the scope of the ChatGPT task force to AI enforcement. And then coming to cross-regulatory cooperation, it is becoming increasingly important as the new digital legislations, including DMA, DSA, AI Act, Data Governance Act, and Data Act, they do build on the GDPR. So the interplay between the GDPR often needs to be taken into account. To give you some examples of that, we, for example, actively participate in legislative discussions concerning the implementation of digital laws. For example, the EDBB adopted a statement on the DPA's role in the AI Act framework. In this statement, we underline that the DPA's data protection authorities should play a prominent role in enforcing AI Act, as most AI systems, they do involve processing of personal data. So data protection authorities, they already have experience and expertise also as well when dealing with the impact of AI on fundamental rights, in particular when it comes to protection of personal data. And this would make the data protection authorities really well also the market surveillance authorities in number of cases. This would also enable better coordination among different regulatory authorities. It would also enhance legislative legal certainty for all stakeholders and strengthen the supervision and enforcement for both the AI Act and EU data protection law. I do believe that data protection authorities are suitable for this role because of their full independence and also the deep understanding of the risks of the AI for fundamental rights based on the experience they already have on this subject matter. As a second example, the cross-regulatory dimension also materializes in the EDBB documents. So in 2024, we adopted some important consistency opinions. For example, the opinion on consent or pay models used by large online platforms and the opinion of the use of personal data to train AI models. For the consent or pay models used by large online platforms, we explain that in most cases, these platforms will not be able to comply with the GDPR if the users have basically only the choice between consenting to processing of personal data for behavioral advertising purposes or paying a fee. So they should consider also providing individuals with a free equivalent alternative without behavior advertising. As these are cross-regulatory, these have cross-regulatory implications, the EDBB, we collaborated with national and EU-level competition and consumer protection regulators to integrate broader perspectives into our assessment in this case. And this cooperation proved very useful in providing valuable input for the consent, for the opinion on consent or pay. We also adopted an opinion on the use of personal data to train AI models. This opinion looks at when and how AI models can be considered anonymous. Secondly, whether and how legitimate interest can be used as legal basis for developing or using AI models. And thirdly, what happens if AI model is developed using personal data that was processed unlawfully? In this context, when working on this opinion, the EDBB met with the AI office and took on board its views prior adopting this opinion. We are also working jointly on guidance with the European Commission on interplay between the DMA and GDPR. So these exchanges, they are some practical implementations of the increasing need of cross-regulatory cooperation when we are applying and enforcing the digital laws. And I am convinced that the new digital rules enable the regulators to jointly draw the line in sand. All of us, yes, all of us approaching the topic from our own perspective, based on our own competencies. And our goal should be to develop innovative yet responsible technologies that uphold EU values and fundamental rights. Finally, before giving the floor to the next speaker, I would like to add that international cooperation and convergence is another important aspect in this context. At the EDBB, we participate or have launched initiatives to exchange good practices with our colleagues worldwide to promote high data protection standards. We are very active in international forums, such as Global Privacy Assembly and the G7 DPA Roundtable. For example, last October, we organized a meeting with all data protection authorities from countries which benefit from EU adequacy decisions. And this meeting was to discuss multilateral engagement on advisory work and guidelines and enforcement cooperation. This brings, for sure, remarkable benefits, including the context of digital legislations.
Thank you so much, Anu. That's provided us with a very good grounding in the importance of cooperation between data protection authorities, of course, at the national level, and then the different ways in which, at the EU level, data protection authorities ensure that consistency, ensure that coherence. I think it's going to be very interesting to build on that experience of cooperation with so many more oversight entities in the digital acquis, particularly in terms of the various roles and interactions to be played by competition authorities, consumer protection, market surveillance authorities, and very significant as well to hear the focus on international cooperation being very much vital to data protection enforcement worldwide. And especially in terms of recent geopolitical developments that make international cooperation a priority as much as possible, even when there may be certain challenges with certain international partners. Charlie, the floor is yours. Thank you.
Thank you, and thanks everyone for attending. Thanks for having me. So on my side, I'm supposed to be the bad guy here around the table, but hopefully conveying a positive message. So I think it's important to keep in mind that our single market is a very powerful idea, and it's a very important element on the legal side. Truth is that it's probably a bit puzzled when you look at how things are actually implemented. We don't have a lot of support to give entrepreneurs access to capital in the EU. You have other economies who do probably a better job there. And that also means that we don't have many tech champions. So if you look at some data, amongst the 50 bigger tech companies in the world, apparently 5 of them are EU ones. Don't quote me on that one. It's coming from a report I will quote later on. But probably it's not even that is so much of an issue. For me, what is even more worrying is that we are lacking like EU digital infrastructure champions. So we don't have the kind of backbone to make sure that we can have innovation that is like built in Europe or with European technology. And that, of course, means that it's probably a more worrying dependency because it impacts not only those in the tech sectors, but like a broader ecosystem outside of tech. So every entity or companies that try to process data, whether they are personal or not personal, they have those questions because we are lacking solid EU digital infrastructures. We are seen, for right or wrong, as champions of regulation. And if you look at a recent paper that was published, which is titled The European Way, a Blueprint to Reclaiming Our Digital Futures, so an initiative led by, amongst others, people that are close to the European Parliament. They made the count, and they count 101 digital laws early 2025. I cannot quote 101 digital laws, and that's probably, even if we put our common brain here, I'm not sure we'll get to 101. But it means that in serving that agenda for a digital decade and for a digital single market, we went through a lot of different types of regulation to try to tackle different types of issues. If we have to try to assess what measuring success of those digital laws could be, I would say for me, the kind of magic combination would be clear rules, smartly enforced, and those enforcement that can then stand in front of courts. So clear rules, it's probably obvious for everyone, but I think clear rules are important and they should be made by politicians because those are the ones who should really be setting the rules. So for rules to work in our field, I believe that we should favor principle-based rules. So the GDPR for that is a very good example. And we should also try to then leave technicians setting up technical things and avoid political discussion at that stage. If you look at how complicated it is to agree on the EU CS certification scheme, for example, because of the popping up of EU sovereignty here and there, I think it's a good example of something that really is not working so well, and probably because we are mixing roles here. Smartly enforce, yeah, as we all know, so enforcement is done with public money, and the resources are not unlimited. So we need to find a way for enforcement to work and to work as it should. Amongst possible options, what we could do or seek to do is make sure that in matters that are capable of those things, we should ask organizations to do reporting, make sure that we then have enforcer being provided with smart data mining tool that then will eventually pop up to flag enforcement action that kind of makes sense. And we probably need to find a way through enforcement models, sorry. So we have very centralized enforcement model, we have very decentralized enforcement model across many different digital laws. I'm not saying that one is better than the other, but I still believe that for very important digital points that really have or touch the heart of fundamental rights, we could be better off in having that kind of a threshold approach, so where you will have a central enforcer in charge of very high profile cases, and then less central or less key matters left to decentralized authorities. That might be an option. And enforcement that stand in court, I think that's really critical if we want to promote accountability. Because when you advise client, they are most of the time very happy to comply if they can understand what they should do. But they also are taking their own risk-based approach in the efforts that they deploy. And if you can securely say that basically those rules are enforced, and when there is enforcement, they stand in court, I think it's a good incentive for people to comply, let's put it that way. Are we seeing that today? I think everyone tries best and try hard to get to those kind of magic combo, but there is probably some work to do. I think I'm probably the most worried about clear rules, because if you look at what we are trying to do, we have entered a new era where basically we now change rules even before they apply, or even before giving them the time to run and see how effective or ineffective they are. And that as well is a bit worrying when you try to advise business of what to do, because if people deploy lots of efforts to try to comply ahead of rules that are going to happen, and then all of the sudden they change, it kind of ruins a bit the effort, but also the incentive of complying earlier. What we can also see, of course, is that there are attempts to change some existing rules, and my personal humble opinion is that probably we are focusing on things that are not really what they should. If you look at the proposed change to the GDPR, it's I think the change are sending a wrong signal. Not that SMEs don't have to be supported. I'm of course all in favor of that, but I think it signals two things. It signals that a layered approach to principle-based legislation can exist, and I don't think that's the right one. And also it signals that basically GDPR is open again, or is open to some changes. While we see, and Carolina, you mentioned it briefly, while we see that on some of the other very important points that probably deserve a reform on the GDPR front, so like better enforcement, all of those attempt to make sure that cross-border cases are dealt in a more efficient way, we see some resistance, at least if we look at the press and the inability yesterday to come up to some agreement. So it's a bit of a battlefield. I don't have many time left, but if we look at some of the enforcement activities as well, or some of the work of the different EU institutions that have to deal with all of those new sets of rules, we also see that my kind of plea for politicians to do politics is not always working, and that EU institutions sometimes are weaponized to get to some outcome that probably is not really part of their fundamental role, or from the outside at least, we can see that some EU institutions are trying to do politics as well. I'm happy to provide further details on that one. Conscious that I have 1 minute left, if we look at the challenge, so to see how all of those all of that landscape plays into actual challenge for organization. I'll just mention those now, and I'm happy to go deeper afterwards. But I think for me, the 4 key elements or demonstration where we see those challenges happening is around children privacy, a big question mark on the AdTech business model, dark pattern, and the EUA Act. So if I just mention dark patterns in 15 seconds, so we have already a number of rules that are trying to tackle and govern dark patterns. So you have it in the Unfair Commercial Practice Directive, you have it under the GDPR, you have it under the DSA, and now we want to cover it again in the Digital Fairness Act. I think it's good to provide different enforcers with tools to act, but if we pile the enforcement tools, we also need to consider those who need to comply with it. And that's where probably the call for consistency is very important, because it's not that people don't want to comply, but if they have slightly diverging rules, it's probably hard to do. Thank you.
Thanks so much, Charlie, for giving us a real sense there of what success would look like, but also how to assess those metrics. I take the point that your greatest worry, which underpinned a lot of the very good arguments you made, was about legal certainty and the need for clear rules. I also picked up on the very excellent point you made about compliance challenges brought about by the simplification agenda. On the one hand, we do seem to have an acknowledgement that the GDPR is the cornerstone or the foundation of the digital acquis, but at the same time, by making changes, even quite targeted procedural changes to specific provisions of the GDPR, it does signal, as Charlie mentioned, that this could be open to broader revision. And then there's also the added challenge of the time that we're living in, the shift in digital strategy to a bolder, faster, simpler Europe. So there's this emphasis on efficiency, but then we do need to take stock in terms of impact assessments, even for maybe those small procedural changes where the GDPR is just so significant as a foundation. And then, as Charlie mentioned, to also take into account the overall digital acquis. The Digital Fairness Act shouldn't be looked at in a vacuum for dark patterns. It sits within an already quite complex framework, already including, for instance, the GDPR. So again, to take into account for industry how all of these new enforcement requirements and tools are then going to be managed by them on the other side, and to make this as clear and as accessible as possible, and hopefully not to create any competition between supervisory authorities, whether external or internal. So, Matthias.
Yeah, thanks for having me. I would like to start by explaining a little what we do as an organization, because it very much determines my view on this debate. At Algorithm Watch, we are a watchdog organization, as the name suggests. So, for example, what we did in the past and what we are still doing is we try, for example, to find out how platforms work. How do we do that? We have a couple of methods, for example, so-called data donation projects, where we ask regular users to donate data to us that we can then analyze, so we are not reliant on the complicity of the platforms, because they usually are not compliant in this. But this already points to the other side of the coin, where we are actively advocating for legal changes. And this example of the data collection points to what we advocated for. That is Article 40 of the DSA, the data access provisions, where we said, you know, in order to be able to understand better what is actually happening on platforms and come to conclusions about what kind of other material changes we need and laws we need to understand this better. So therefore, we first of all have to, and I'll say it, force the companies to provide data to us. So in this sense, I'm sort of walking a fine line, because on the one hand, you know, the European Commission and the legislator is an addressee of ours, because we are asking them to do something to, for example, come up with new laws that are in our interest. And at the same time, of course, we are heavily influenced by the laws that are already there. So, for example, if you collect data from people, you have to be compliant with the GDPR, and that can be very hard in practice, especially for a small organization like ours. We are 25 people in Berlin and 6 people in Zurich, and I'm German, so you can imagine that I don't have a naturally high expectation of consistency of law when we have a country where we have 16 federal states and 18 data protection authorities, right? So this is like the situation I'm coming from. And how does this determine my view on what is happening? Well, I honestly am not surprised to hear that this report comes up with a number of more than 100 laws governing the, let's say, the digital world. And part of that is, and this is not something negative, but an observation, is that I think this is not surprising because we don't live in an analog world anymore. There is no such thing as an analog world. So is it surprising that we have a ton of regulations that you could describe as digital regulations? Not really, right? Because everything now that we are doing is at least partly determined by the exchange of data, by information technology, and so on and so forth. But I think what has been happening over the last couple of years, and this is where I'm saying I'm walking a fine line, is that there were, of course, a plethora of activities and initiatives, and we supported many of those. I already gave you the example of the DSA. With others, we were in the situation that from the outset, we were very critical. For example, the AI Act. My personal interpretation is that the AI Act exists because there was an AI hype. Now we're all looking back and saying, where was that AI hype? Because ChatGPT is here and there's basically everyone talking about AI day in, day out. But at the time, there was already an AI hype because machine learning was becoming more popular, and companies were making very, very bold claims, as they always are, saying that this will change the world and we have these wonderful capabilities and so on and so forth. That created a backlash. That backlash was, there's an enormous risk here, and there are harms, right? Tons of them. I could provide you with a list if you wanted. And this backlash then led to a situation where Ursula von der Leyen, in her first term, came in and said, we'll have a regulation on AI in the first 100 days, and I imagined the people running around in the commission screaming, and of course it came in a sense different. There was the white paper, but in the end there was the AI Act. Why were we critical of this? Because we would have preferred a different approach, in the sense that let's look at the domains and let's see what happens in these domains and then try to regulate from that perspective. But we didn't have that opportunity because we couldn't argue that, no, there shouldn't be any regulation, as the companies would do, say, leave us alone, we know what to do. That was not an option for us as a human rights organization. So there was a path dependency created very early on, right? And that then leads to a situation where I would also agree that we don't see a, let's say, high consistency and coherence in the digital legislation on the EU level. Now, who's to be blamed for that? I mean, it would be a cheap shot to say, yeah, the Commission is making bad laws. Everyone here knows how regulation on the EU level comes about and the process, including the trilogues and all that. But yes, I agree in the sense that we need to have more consistency and coherence. And here I would make the argument that there is a difference between consistency and coherence and simplification, because simplification very often is just used as a buzzword to say we have to get away with these laws, right? Give us freedom, give us more liberty, give us more, leg room, and everything will be fine. I don't think that is the case. We had in the past good examples of regulation that created innovation, and this whole dichotomy between, you can either have regulation or innovation is false. I mean, this is CPDP. Many people agree with this here, so I'm not making a bold statement, but I would like still to remind us. And I mean, coming back to the key questions about the trends, I think I already talked about no, I didn't really talk about this trend, because the trend is not more regulation, but at the moment the trend is, of course, the simplification thing, and this is very dangerous. So key actors, well, the US government, right? I mean, no one has mentioned this so far. It's the elephant in the room, and I personally participated in the AI Action Summit in Paris, and there was this idea that the main theme of the summit should be something like a sustainable AI ecosystem. You know, then Trump came into office and announced the Stargate initiative, and immediately everything was thrown overboard, and it was just competitiveness, come to France, you know, use our nuclear power to build your data centers. And then the EU initiative with Invest AI came about, and you know, you clearly get the idea that there was a change of course, and now we just need to look at how to compete in the race, not win the race, but to be able to compete in the race against the United States and China. I think this is a wrong framework. I need to stop here because I'm running out of time, but if we want to discuss this in the next round, I'd be very happy to do so. But how can we measure then? I would like to withhold comment on that because I'm completely not an expert on this. I think what I can say is you need to do it like legislation by legislation. I can give you the example of the DSA because this is what I'm knowledgeable about. It came fully into force in February of 2024. I told you about the data access that we are interested in. If you want to file a data access request to a company specifically, you need the delegated act about data access. It's now May 2025. We still don't have the delegated act. It was said that it should be published in the second quarter. Now we hear it's not even going to be published in the second quarter, then there will be a grace period. So, you know, it may take 2 years after the DSA came into effect before we can file the first data access request, you know. If you want to put this into a metric, I'd say it's a fail.
Well, thank you, Matthias, for your very frank and candid perspective from the civil society view. I think it's very significant that you focused on new provisions within the digital acquis to address these issues of power asymmetry between individuals, governments, but specifically big tech. And I think the data access provision that you mentioned in the DSA is very significant in that respect. But as you rightly point out, it's only significant once it's operational. So in terms of a focus on efficiency, that is obviously a step forward that needs to happen in order that we can reflect on how that's been impactful. So I think that's very significant. Thanks also for your point regarding the trend that, well, we're no longer in an analog world, so it is no surprise that most of the legislation we now have in Europe is very focused on the digital. So it's a very relevant and important point to be making. And I think it's, you know, equally important to address, you know, I think you mentioned a few elephants in the room. It's like there's a whole bunch of elephants that have just joined the room now, but we have that focus on the need for a shift to a competitive Europe, but how do we reconcile that with all of these other objectives, the rule of law, fundamental rights, legal certainty, coherence? And I do take your point as well about the role now being played by simplification, and there are concerns, they've already been expressed at other panels at CPDP so far, that simplification, which we've had a long time in EU digital policy making as part of the better regulation agenda for clearer rules, efficiency, also evidence-based policy making too, which is very significant. I think personally we need to have a lot more of that. But the concern here is that simplification has been recast as a justification for deregulation. And that is a very significant policy shift that is being signaled. And there are real concerns that external forces and international partners are forcing that particular narrative, and we saw it in various policy statements by the US administration, where you have executive decisions on AI where the US, in no unequivocal terms, says that it wants AI dominance in this global policymaking space. Whereas I think, to be fair to the EU legislature, the focus has always been on the EU being a global leader in AI, so that it recognizes the role of the EU in terms of being more competitive in that space, but that this shouldn't come at the expense of the role of it, to use Charlie's terms, being a champion of digital regulations that makes AI trustworthy, makes it safe. So, Max, finally, your moment, please.
Thank you. Yeah, I have the honor to conclude at least the first presentations, and I think it's also a bit challenging because of my function as an academic here, because what is the function? Well, I'm deemed to observe all the opinions from the different stakeholders, right? From the regulator, from the enforcement authorities, from the processing entities, or lawyers representing them, companies, and from the civil society. And now I shall bring all that into a systematic perspective. And why? Because with this systematization, I might help all these different actors to coordinate in a way to find their common goal and to achieve that goal in a most efficient way. And this is what I now really try to do. Let's see whether I succeed.
Good luck.
So, yes, I see two goals from the EU and from all of us actually, being Europeans. So one is that we really want to enhance these data-driven innovation capacities. So in order to promote public welfare, etc. It's not only about money, it's also about public welfare in general, so better medicine services, whatever, social innovations. And on the other hand, we really try to do this based on our European values, so democracy, solidarity, maybe oversimplified spoken, taming the powerful, not to misuse their power, and enabling the powerless, so to let them participate also in the value creation of data-driven innovation. This is the nice goal, a nice society. And if you want to bring that into one formula, now becoming a little bit more academic, you can sum it up as, in the end, everybody must meet one equation, namely that the value creation in the end through data-driven innovation is higher than its risks and its costs. It's a super simple formula, but it has really some power in it because it gives each stakeholder a certain KPIs, or let's start an approach to define some KPIs, because the legislator can now ask each law, what I'm pushing out, is this actually helping all the others to meet that equation? Or am I too much on the risk side, or too much on the cost side, or too less on the value creation side? And the same applies to the enforcement authority. They can also ask themselves now, hey, what can I do to help all the other actors to meet that equation? And the same is, of course, true with the companies. And they are, if you apologize, I become a little bit even more critical, because I think that the most innovation capacities currently come from the regulator, and not so much from the companies. And now I go to my own discipline, namely the lawyers, and I really wonder if you put them into that equation. I think what they mostly doing is increasing costs and not solving the compliance risks. And this is something what I really wonder, and where this own discipline should really think about, hey, how can we actually help our clients to really get this compliance risk done and stop complaining about, oh my God, the law is so complicated. I mean, of course, it's also up to the legislator to simplify the law, but in the end, it's the lawyer's job to help their clients to make that really happen in practice. Yeah? So if you now look at the different laws in the last years, it mainly focused, especially in the beginning, on the risk side. Yeah? So the GDPR, protecting against processing risks, the AI Act, even better, protecting against AI risks, also the DSA, protecting against platform risks. And the question is here now that it's very nice to see that, of course, this protects us as individuals and also groups and the society as a whole, but from the processing entities perspective, who are actually deemed to create the value of data-driven innovation, this turns, like a flip side, into a compliance risk. And the problem then is, how can they deal with these laws in a way that the equation is still met in the very end? And this brings us to the very nice question, what can we do there? And I also agree with you, for example, it's not about reducing the regulatory burden, but it's about reducing legal uncertainty in order to reduce compliance risk. And this is mainly done by clarifying competencies and clarifying the procedures on the operational level, so that the entities which must comply with the law get through it as easy and efficient as possible. And this is, I think, where we should take all our attention on how can we operationalize these laws. Not by producing even more laws, but really looking at the procedures of application. So in the last years, the legislator broadened its focus away from the risks, not completely away, but now also focusing on the value creation. And this is a super good thing, because it makes the picture round. And I just give you a couple of examples. For example, the Data Governance Act is a super nice example. I was very critical in the beginning, but the more and more I observe the different data intermediation services popping up, I believe more and more this was really a brilliant idea, because it's really working in practice. So in the moment where it's a soft law, right? It's voluntary, but in the moment an entity sets up, gets the stamp from a public authority and says, "Hi, I can solve your compliance risk problems." This has a very much, this has really a high power. So another example is even more rigid, or it's a hard law, is the Data Act. So now it's really about how can I enable the powerless to also profit from the value creation of the data they also co-produce, right? So a very nice example. But here again, the question is, how can these laws finally be operationalized, especially by the smaller companies, so that the costs for doing so do not jeopardize the expected value creation? So this is the biggest question here. And this gets even more sensitive, this question, if we realize that if we look at the current power structures, we know from many, many, many empirical studies that the big ones have actually no problem of applying the laws. Even if you hear Facebook, Meta now lamenting that a NOIB would be too powerful. I mean, this is a bad joke, right? They have such a big legal department, they can apply each law if they really want. The problem is rather for the very small companies in Europe, mostly, which are actually deemed to profit from these laws, but they don't have the procedures to do so in a cost-efficient way. And this is why I think it's really the conundrum where our all efforts should focus on in order to make that European idea really a success.
Thank you so much, Max. So I just checked the time, and we are running a little bit over in terms of format. So in the interest of giving everyone as much an opportunity as possible to raise a question for the panel before we close for lunch, which is in about 9 minutes, I'm trying to be a very diligent chair and having a look in the audience to see any show of hands now. And yes, we have hands, wonderful. We may just take these questions collectively, if that's all right, to maximize time. So if you could just briefly introduce yourself and your question for the panel. Thank you.
Sure. First of all, thank you for this wonderful panel. My name is Erik Valgaeren. I'm a practicing lawyer here in Brussels in digital and data law. I have 2 questions. The first one is, can we not then make sure that we introduce Max's formula in the impact assessment phase of any contemplated new legislation? Because to me, it seems that right at that moment in time, i.e. before we crank out all the new rules, we should be applying that formula. The second one is, in the way we look at the costs and the formula, should we also think about the extra costs that probably will be required at the level of our European Court of Justice to deal with all the new preliminary questions that will be hitting them in the next few years, because I think they will probably need to at least double the size of their teams in order to absorb all of that. Thank you.
Thank you so much. Speaking as a previous judicial researcher, yes, help the judicial researchers as much as possible, absolutely. Next question, please.
Hi, my name is Sebastiaan Bargeval. I work for the European Data Protection Supervisor. I found the panel very interesting, so thank you all. My questions were for Caroline. I found your remarks, of course, very in line with a lot of the work that we have been doing this year on promoting consistency and coherence at the level of the data protection authorities. You mentioned, of course, proliferation of different legislation, GDPR as a cornerstone, need for, clarifying interplays, etc. There's also, with proliferation of regulation, proliferation of regulators of all of these laws, proliferation of boards in different legislations that need to ensure consistency within those laws, right? An exception maybe is the DMA high-level group that has sort of a trans-regulatory impact. My question is, and you also referred to national initiatives fostering cooperation between regulators from different fields, such as the Digital Cluster Bond. How does the European Commission see a platform for making these different boards across different legislations talk to each other? This is the idea that we have been promoting at the EDPS for a digital clearinghouse 2.0. There's a paper that we published on this in January this year, so sorry for the self-promotion, but it really would be very interesting to hear your ideas, and also in terms of legal mechanisms for these authorities of different fields to share case-related information with each other, because authorities often complain that because of confidentiality, concerns, etc., they cannot share information across legal fields for investigation. So these are my two questions. Thank you.
Multiple questions. One more question, please, and then we will turn to the panel. Thank you so much.
Thank you very much for the wonderful panel discussion that we had. I'm Swati Jagannath from Red Bull GmbH. And my question, I share my concerns that Charlie pointed out earlier, that we have a range of laws in the digital sphere, and now we have another one with the Digital Fairness Act coming in, tackling some issues that are already addressed in others. So my concern as a practitioner, going back to my bosses and then to my clients internally, would be how would this new legislation, if it does come into place, how would compliance look like for this or any other related digital legislation that comes into picture? How would all of this interplay with something that we already have? Would this add more compliance burden for us, or this would work together with that compliance procedures we already have? So I think my question is towards the regulators and the enforcers. Thank you very much.
Thank you so much for these really excellent questions. A very quick response would be the interplay between the data protection impact assessment requirement under GDPR and fundamental rights impact assessments under the AI Act, in terms of the interplay between those, for instance. So to wrap up, if we could perhaps start with Max, work our way back, and then nobody will be delayed for lunch. I see some very concerned faces out there, but don't worry, you're in good hands. We're about to wrap up now. Max.
But by answering a question now, or just wrapping up?
Both, please. Thank you.
Since most questions were actually directed to the regulators, I would just say, yes, I agree with these questions. However, I would not push everything to the regulator, but I think it's really also up to us, the companies and the lawyers and the civil society and me, the academics, to really build the solutions on the operational level. It's not only the legislator who can solve the problems.
Thanks so much, Max. Matthias?
Yeah, well, I'll just pass on the mic because I think there are other people more qualified to answer the questions, and I think that's what's most important right now.
Yeah, thank you. So very quickly on my side, so a call for pushing the stop button on new regulation and try to work out together how best to comply with them. Thank you.
Thank you. I think that many of the questions comes back to the point that Max made about the need to reduce the uncertainty. And this is why the cross-regulatory cooperation is very important. It's also important to reduce the overlapping tools or interpretations, and this is why we at the EDBB we have set a lot of focus on that already. And also we have set a lot of focus on small and medium-sized enterprises, trying to make it as easy as possible for the small and medium-sized enterprises to comply with the GDPR. This also reduces the uncertainties. So.
Thank you very much. Indeed, well, I found a lot of reassurance by the fact that actually there was a common theme. Everybody was pleading bottom line, and Charlie, please do not let me to put words in your mouth, but for not so much less regulation, but smarter, coherent regulation. And I think what we did yesterday was just removing really a very formalistic administrative burden. It's not about what this thought and theme about smart regulation and smart enforcement, and here I'm turning to the enforcers a little bit, and we spoke about it before, is about. I think we are fully agree. Yeah, the decision needs to stand in front of the court, and I think that our procedural rules with the providing for very clear settings in the GDPR, at least in cross-border cases, could help there. Now, I take very much the call for clear rules, but I think everybody understands it a little bit differently. I don't think here anybody would plead for removal of the risk-based approach. Right? So this flexibility we have in the adjustment. I was recently confronted with arguments that actually Artificial Intelligence Act, it's already too strict because it freezes the assessment of the risks too much. So where should we do it? We think, and in the Commission so far, I don't know what will happen, we defend very much this approach of flexible, risk-dependent rules, which in a more flexible way will be not readjusted, but the legal certainty will be induced by flexible tool of guidelines, right? Which can be readjusted if necessary. So there, really, I take this call again for what centralization, if I understood you correctly, Charlie, with the threshold. I will take it home with me. Matthias, point taken, data access, it's the implementing act there. We work on it. There was a very extensive public consultation on that, and indeed. Well, to answer to the questions, Sebastião, a bit self-serving, I'm sorry, and the only answer I can give, the Commission has received the document from the EDPS on a clearinghouse. Of course, we read it with a lot of interest, and the question concerning the access to or possibility to share data collected by enforcers under different pieces of legislation needs to be very carefully assessed, in particular from the point of view of prohibition of self-incrimination, right? So this is also something very important. Maybe here, answer to the last question, and also coming back to Charlie, Data Fairness Act, it's not supposed to revamp and redo everything. It's supposed to be about and it's the reason we are running now this study, in order to map where do we really need to address specific needs of the consumers, right? And there the needs are also a little bit, we are speaking about influencers who are still not regulated, and which patterns of behavior and which endanger the position of the European consumer we see there. The second element would be online contracts. A withdrawal of the contracts, all the problems our consumers face while trying to get rid of the online contracts, dark patterns. There, I hear you, and we are very much aware of the fact that it's already regulated under the GDPR, under the DSA, and so on. But for example, of advertisement, the question is very much about should the solution from the DSA be applied more horizontally. So I think this would be done very, very quickly. Thank you.
Well, I will take this moment to note that we perhaps have some more questions on the emerging patterns in digital regulation than perhaps we started off with. But I certainly believe that we addressed those 4 key questions that we started off with in terms of metrics to be considered, the focus on simplification being clarity, legal certainty, and coherence, taking stock of where the digital acquis is now, for instance. I think another important point raised by Max was the challenge of operationalizing these different frameworks in terms of compliance. I will respectfully disagree that not everybody can call their lawyer for advice. So I think there's a balance there in terms of the guidance and compliance that can be provided by national data protection authorities, those other authorities at the national level too, market surveillance authorities, all of those bodies at the EU level, and to see how this is going to trickle down and help individuals in every type of organization, SMEs and individuals, and particularly in those organizations with fewer resources in the public sector, as you mentioned, Max, schools, health, hospitals, where there are already huge strains on data management and data compliance. One particular piece of feedback, since I have 2 regulators here on the panel that I'd just like to pay forward, is interoperability in terms of assisting for individuals on that technical basis. And again, I think that brings us back to the point again of legal certainty and simplification for improving coherence and clarity, and not a recasting of deregulation. So with all that said, please join me in thanking our panel and for the excellent questions from the audience. Thank you.